rise. Application in the matter of the Queen on the application of Hoareau and another, and the Secretary of State for Foreign and Commonwealth Affairs.
My Lords, I appear with Mr Luckhurst and Mr Haddislasi for the first appellant, Mrs Varro, Mr Fitzgerald and Mr Harris for the second appellant, Mr Bancoult, and Sir James Eady, Mr Beale and Ms Wilkinson for the Secretary of State.
Yes, thank you. Technically, I think, I meant to check, but Lord Justice Hickinbottom's order doesn't give Sir James Lockhurst. It's a you can attend if you like type order. You won't be surprised to hear that if there are points on which we would wish for his assistance, we will be asking for them. But we'll see whether that arises.
Great. I hope you have an updated and consolidated hearing bundle that goes up to tab 26.
Yes.
So everything is, or at least ought to be,
in the one place.
Over the weekend, the Secretary of State has produced an additional volume of documents and authorities, which I hope has also made it to the court.
It probably, yes, it has. That's this one here with nine items in it. Is that right?
What the
this one here. Oh, that one. Right. Thank you.
with the court's permission, what the proposed appellants intend to do is to divide the submissions in the same way as below. Mr Fitzgerald will deal with the right of abode issue, and I will deal with the European Convention on Human Rights, the public sector equality duty, and the support package. Before I do that, though, I'm proposing to mention the International Court of Justice's advisory opinion,
yes,
which was produced after the Divisional Court handed down judgment, and is likely in my submission to be of particular significance to the Convention arguments.
you will have to persuade me that that is the case, but I have certainly read it. I'm sure my Lord has as well.
The court's already familiar with the nature of the decision, which is under challenge. There are three bits that are under challenge. The first element is not to provide any financial or material support for the resettlement of any Chagosians.
Sorry, just one other thing, Mr Jaffe. This is down, you don't need reminding, this is a permission application.
Yes.
And therefore your submissions will be with a half-day estimate. We started at 11, so technically that means you're allowed to go into the afternoon. But realistically, what we would hope would happen is that we could hear from both applicants by the short adjournment, if not before. We will then take the opportunity of the short adjournment, or any earlier rising, to see where we are and to decide whether and on what points we need to hear from Sir James.
Yes.
Thank you. Sorry, I interrupted you, but I thought you'd better just know that...
No, I'm very grateful for that indication. That's very helpful. The first element is no financial or material support for resettlement, and secondly, that the legal bar on the return of any Chagosians would not be lifted so as to permit any resettlement, and then thirdly, that there'll be a support package over 10 years in the sum of approximately £40 million. Those are the three elements. Mrs Hoareau challenged...
So sorry, I didn't get... the accurate one is... So the second one is...
The second one is the decision that resettlement would not be permitted, even if it's not financially supported, and thirdly, the support package.
Yeah.
At the same time, a decision was made to roll over the exchange of notes with the United States of America for a further 20 years. There is no challenge to that decision. So 4 decisions were made. 3 are challenged by Mrs Hoareau, and the first 2 are challenged by Mr Bancoult. The reason for that, as the Divisional Court explained, is not because Mr Bancoult doesn't agree with the ground of challenge to the support package, but as a matter of principle doesn't consider the support package to be in any sense a mitigation for the loss of his home. I'm not going to go through any of the history of the Chagos Islands litigation, but can I just mention by numbers a sentence on each of what the cases were, just as a reminder to the court. Bancoult number 1 was the challenge in 2000, about 20 years after its introduction, to the removal of the right of abode, which was successful. and led to legislation restoring the right of abode between 2000 to 2004 to the outer islands of the archipelago only, not to Diego Garcia, which remained a military base. That was then followed by the Chagos Islands litigation, which was a tort group action heard by Mr. Justice Ouseley, which was dismissed in 2003. Then in 2004, the government removed the right of abode that it had restored in 2000. That led to Bancoult number 2, decided in 2008 in the House of Lords, and that claim failed by a majority. Bancoult number 2 then went to the European Court of Human Rights. That's the Chagos Islanders and the UK claim. That was decided in December 2012. Then since then, Bancoult number 3 was a challenge to the declaration of a marine protected area around the outer islands, plus various issues about diplomatic documents. That claim reached the Supreme Court and is not relevant for the purposes of today. Then Bancoult number 4, decided by the Supreme Court in June 2016, was the application to reopen Bancoult number 2 based on alleged non-disclosure by the Secretary of State. That claim was unsuccessful, also by a majority. And then this case is Bancoult number 5, which was decided by the Divisional Court on the 8th of February with the ICJ opinion hot on its heels. Can I turn then straight away to the ICJ opinion, which is in the authorities bundle at tab 9. As the court will know, the UN General Assembly voted to request an advisory opinion, which the UK participated in full, and therefore the court had the benefit of contested arguments, plus I think oral interventions from over 20 other states, and it was decided by a large majority of 13 to 1 in favour of the arguments advanced by the state of Mauritius. The two questions which the advisory opinion addressed are at page 7. The first one relates to decolonisation and whether it was lawfully completed on Mauritius' independence in 1968. And the second question concerns the consequences in international...
Sorry, where are the two questions?
I do apologise, my lord. At the top of page 7 of the report, it's an unnumbered paragraph, or possibly part of paragraph 1.
Yep, thank you.
The second question asks what the consequences are in international law of the United Kingdom's continued administration of the islands, including the inability of Mauritius to implement resettlement of its nationals, in particular those of Chagosian origin. So the question of resettlement was raised and considered by the court. The court rejected a number of preliminary arguments about jurisdiction and discretion. First of all in the judgment, which we don't need to deal with, and then the facts are set out from paragraphs 94 onwards on page 24. The account of the facts goes on to paragraph 112, which I'm not going to go through, but the upshot was that there was a plan to detach the territory from Mauritius. The United Kingdom knew it would lead to criticism within the United Nations. The aim was for the island to be free of all civilian inhabitants, and then the court sets out an account of the process of the negotiations and the position of the Chagosians. Then under the heading on page 28C, the situation of the Chagosians, there's a short history of the position of the Chagosian people, and the government's position is recorded at paragraph 116. It fully accepts the manner in which the Chagosians were removed and the way in which they were treated was shameful and wrong, and it deeply regrets that fact. There's then a record of all of the litigation which has taken place, which goes through to paragraph 131. Now, the law, so far as it's relevant to this application, starts at paragraph 144, and the key provision is Article 73 of the UN Charter, which is quoted at paragraph 146. and that is the duty on colonial powers, and I add in parentheses, such as the United Kingdom in relation to the British Indian Ocean Territory, to develop the self-government of peoples under administration. And that is explained further at paragraph 147. The legal regime of non-self-governing territories was based on the progressive development of their institutions so as to lead to the populations concerned to exercise their right to self-determination. And the court explains at 148 it now has to determine the status of that provision, including whether it's a customary rule which is binding on all states. So has that principle of international law reached the status of customary international law? The court then conducts its analysis over the following 2 or 3 pages. It does what international courts do when considering customary international law. It cites various examples of state practice, including various General Assembly resolutions. And then the court sets out its conclusion at paragraph 160, which is the conclusion of the court expressed in emphatic terms. I won't read it out, but I will assume that the court has had an opportunity to read it already. The upshot.
Let me just reread it. Yes, thank you.
So, the right of self-determination has the character of being customary international law, and it also includes within it a principle that there should be no partial or total disruption of the territorial integrity of a territory. So the purpose of that is to avoid parts of territories being split off or divided. And of course that has been an important issue through the history of decolonialisation, as territories have been split and divided as part of that process. Those principles are then applied to the facts from paragraph 172 onwards. The first thing the court does at 172 is to dismiss the argument that Mauritius consented to the arrangements. Although there was consent, the court explained in the second part of 172 it's not possible to talk of an international agreement when one of the parties to it, Mauritius, was under the authority of the latter. It requires heightened scrutiny, and then the last sentence, the detachment was not based on the free and genuine expression of the will of the people concerned. And that leads to the conclusion at 174 that the Chagos archipelago was unlawfully detached, and its incorporation into a new colony known as Biot meant that the process of decolonisation was not lawfully completed. So that's the historical question. The court then turned and dealt with the second question that was referred to it, and starts to set out its conclusions from 177 onwards. Having repeated its conclusion under the first question, in the third line of 177, it follows that the UK's continued administration of the archipelago constitutes a wrongful act entailing the international responsibility of the state, and then there's citation, and then the court says it's an unlawful act of a continuing character which arose as a result of the separation of the archipelago from Mauritius, and then the duty on the United Kingdom is spelled out in very clear terms at 178, under an obligation to bring to an end its administration of the archipelago as rapidly as possible. Then, in relation to the issue of resettlement, that's dealt with at paragraph 181 of the judgment on page 43. And from the second line of 181, the court says this is an issue relating to the protection of human rights of those concerned, which should be addressed by the General Assembly. Now, the United Kingdom is, of course, a dual estate, so what is the relevance, if any, of this advisory opinion? Well, the answer to that is that the European Convention on Human Rights is, wherever possible, read and operated compatibly with other obligations in international law. And that's the effect of Article 31 of the Vienna Convention on the Law of Treaties. And there are many recent examples of the Strasbourg Court applying that principle in its jurisprudence. To take a couple, Hassan and the United Kingdom, where Article 5 of the Convention was read down to permit lawful detention under the Geneva Conventions, or the Serdar Mohammed case in the Supreme Court, which did something rather similar in relation to UN Security Council resolutions. So convention rights are read and applied compatibly with other international law obligations. And a good recent example of that in the context of the Court of Justice of the European Union is the Western Sahara case that we have cited in our skeleton argument. I'm not going to take the court through it, but it's at tab 11 of the authorities bundle. There was a treaty between the EU and Morocco permitting certain fishing to take place in the territory of the Kingdom of Morocco. Now, Morocco thinks that Western Sahara is part of the state of Morocco. The international community does not, because of the right of self-determination under Article 3 of the UN Charter of the Western Saharan people. The court held that the scope of the treaty did not include Western Sahara. And that was because, if it was construed as including Western Sahara, the EU would be assisting or recognising a breach of the public international law right to self-determination. And that's paragraph 63 and 64 of the decision of the Grand Chamber. So that's the principle. Applying that principle to this case, in order to overcome the Divisional Court's judgment, I need to show an arguable case on 4 points. First of all, that the British Indian Ocean Territory is within the territorial jurisdiction of the Convention.
Hang on one second.
Secondly, that Mrs. Varro is a victim under Section 7 of the Human Rights Act. And thirdly, that the substantive rights, and we have relied on Article 1 of the First Protocol, which is the right to property, and Article 8, the right to privacy, are engaged. And finally, if they are engaged, that there has been a breach of those substantive rights. Now, the Divisional Court answered no to the first 3 questions, and therefore did not address the 4th. And so the Divisional Court's judgment on jurisdiction, if I could ask the Court to briefly turn it up, starts at paragraph 129, and the judgment's in tab 7 in the bundle if you still have it there. The Divisional Court said at paragraph 129 of its judgment is that the first and decisive objection to the Human Rights Act claim was the absence of a declaration under Article 56 of the Convention. And Article 56 of the Convention is set out in paragraph 130. It allows a state to declare that the Convention applies to territories for whose international relations it's responsible. And the Divisional Court's conclusion was that the decision of the United Kingdom not to do so in respect of the British Indian Ocean Territory was final. And in particular, there was no alternative route to jurisdiction relying on Article 1 of the Convention, so relying on control of territory in cases such as Al-Skein. Now, the Divisional Court relied on 2 authorities in support of that. First of all, Bancoult number 2, and secondly, Bancoult number 2 in Strasbourg, which is the Chagos Islanders case. I won't take you through Bancoult number 2 because the quotations are set out in the Divisional Court's judgment at paragraphs 132 and 133. And the analysis of the House of Lords, in particular of Lord Hoffman, is quite brief. What Lord Hoffman said is, first of all, that a declaration was made in respect of the colony of Mauritius. That declaration lapsed on independence, that Biot is a new political entity to which the Convention had never been extended by the United Kingdom, and therefore in the absence of a declaration under Article 56, there were no jurisdiction to consider a claim of breach of the Convention rights. So that's the brief reasoning in Lord Hoffman's judgment, which, as I'll develop in a moment, is undermined in my submission by the ICJ judgment. But what it led to is the Chagos Islanders decision in the European Court of Human Rights. That judgment is at tab 8 of the authorities bundle. I could just ask the court to briefly take that up. Just so the court has the timing in mind, Bancoult number 2 in the House of Lords was decided before Al-Scani in the Grand Chamber. Al-Scani in the Grand Chamber was then decided in the interim before the Strasbourg Court considered the Chagos Islanders case. And so, unsurprisingly, given the important development in the law that that case marks, it featured large in the arguments that were made in the Chagos Islanders case. And at paragraph 40, the court sets out the government's case, which essentially repeats the conclusions of Lord Hoffman in the House of Lords and explains in relation to Al-Scani, which is cited at paragraph 39, picking it up 3 or 4 lines into paragraph 40, the concept of state agent authority and control and effective control over an area were not intended by the court to supplant the declaratory system put in place by Article 56. So that's the government's argument. The applicant's arguments are set out or summarised at paragraph 49, and the applicants say it's a question of fact, and the United Kingdom in fact exercised total dominion over the Chagos Islands, and then set out the circumstances.
Sorry, I just was making a note. Where is the paragraph?
The applicant's arguments are paragraph 49.
The particular bit that you were quoting.
It was 3 lines into paragraph 49, or 2 lines in,
Yes, thank you, I have it.
setting out total dominion over the Chagos Islands.
Yeah.
The court then analyses the issue, and then ultimately, at paragraph 75 and 76, the court decides it's unnecessary to rule on the argument because the applicant's complaints fail for lack of victim status.
It's fair to say that before making that decision, they express strong sympathy with the government's arguments.
They do. That's absolutely right.
But you say, all right, but they didn't decide them.
They say they didn't decide them. And what I'm going to submit is that in light of the ICJ opinions, a different approach is going to need, I suggest, to be applied.
So even if they had in fact decided the point on the basis of the sorts of points that they make at 71 to 74, you would say those are themselves to some extent undermined by ICJ, certainly need to be looked at again.
Yes. I'm afraid that even if the Chagos Islanders' decision had been as my lord suggested, I would still be here. So what do I say the effect of the advisory opinion is? Well, the first problem in my submission the Secretary of State has got in light of the advisory opinion is that the detachment of Biot from Mauritius was unlawful in international law. And the reasoning of Bancoult number 2 is based on that detachment having taken place and by assumption that it was lawful. For the European Court of Human Rights to recognise that the original declaration in respect of Mauritius has now lapsed as a result of an unlawful act of detachment would be for the European Court of Human Rights to give effect to an unlawful act in international law. And the effect of permitting recognition of that unlawful act would be to remove fundamental rights. That would be the consequence of recognising the unlawful act in international law. So my first submission is that a detachment can only be a valid detachment. The appellants don't see any basis on which the European Court of Human Rights will recognise the validity of an unlawful detachment of territory with the effect of removing convention rights.
So the way this would work, just spelling it out for myself, is that Article 56, the Article 56 declaration that was made in relation to Mauritius, effectively remained in place for the purpose of the convention.
Yes, unless and until the United Kingdom renounces it. But what they can't do is say by an unlawful act of detachment, which creates a new territory, unlawfully in international law, I add in parentheses, they have succeeded in getting rid of the Article 56 notification.
Is that a point that arises when you get to the Supreme Court?
Yes, I mean, one of the points that was taken against me by the Divisional Court is that what about Bancoult number 2? Whatever developments there may be, aren't you going to have to address these arguments to the Supreme Court? And we had an argument about this, and I said that Al-Skani can now be viewed as part of domestic law as a result of a series of decisions in the Supreme Court implementing it.
Well, you might argue that they the Supreme Court in Bancoult number 2 didn't decide Article 1 jurisdiction.
Exactly, because it wasn't really an issue at the time, because that was the world of Bankovich, where it wasn't even considered. They simply considered the question of detachment. Now, we had an argument about that in the Divisional Court, and I lost it, and the Divisional Court said that they were bound by Bancoult number 2. Now, let's just assume, for the purpose of this permission hearing, that the Divisional Court were right about that. The consequence is not, in my submission, that the appellant should be refused permission. They should be granted permission in order that the case, if necessary, can go to the Supreme Court. Now, the alternative is that permission is refused and the appellants will go direct to Strasbourg. Now, in one sense, it's actually slightly beneficial for them for that to happen, because they're not getting any younger and they will have exhausted their domestic remedies and they can run these points. But the difficulty with that is, as a matter of principle, that the Strasbourg court won't have the benefit of any judgment at any level in the domestic courts, considering the effect of the ICJ advisory opinion on convention rights. And so that process of dialogue that the Strasbourg court has found valuable in the past will not take place. And so that's why I say, as a matter of principle, even if this court, just as the Divisional Court, is bound by Bancoult number 2, and I don't want to go through all that again now, unless we have to, the proper course is to grant permission rather than...
So for the purpose of this hearing, you're putting your eggs in that basket, while no doubt reserving the position, if we do give permission...
To say that you're not bound, yes.
Yes.
Simply because I don't think it makes any difference to the outcome of an application for permission. The second difficulty that the Secretary of State has in light of
Sorry, just give me 1 minute.
I do apologise.
Since I have interrupted you, when I first read the papers, I noted somewhere, but when I came back to them, I didn't have time to pin it down, a suggestion that if we give permission, we should facilitate or do whatever is necessary. I haven't checked the rules to see that this should go direct to the Supreme Court. I'm not quite sure how we would do that, or have I imagined that?
I think what happened before the Divisional Court is that Mr. Bancoult asked for a leapfrog certificate, which was...
I see, but that not having been given is too late.
No,
As I wasn't quite sure how it could be done.
The only route of appeal is through this court at this stage.
Okay,
I
that's
respectfully agree with that. The second difficulty that arises for the Secretary of State after the ICJ advisory opinion is that Article 56, which the Secretary of State says is the only proper route for establishing convention jurisdiction, can only be used to make a declaration in respect of territories for whose international relations the United Kingdom is responsible. So we have to construe the words "is responsible." Now, the proper interpretation, the appellants say, of those words must mean lawfully and properly responsible under international law, not unlawfully. And that again is as a result of the effect of Article 31 of the Vienna Convention. It's really the same issue as arose in the Western Sahara case, which is that an international court, and indeed this court, when deciding on the meaning of the convention, will not readily construe the convention so as to give effect to and support a breach of international law. And the ICJ opinion at paragraph 177 says that the United Kingdom's continued administration of the Chagos Islands, which of course must include continuing to manage its international relations, constitutes a wrongful act entailing international responsibility. So the position that we are currently in is that the United Kingdom is seeking to rely on its own failure to make an Article 56 notification, even though its failure to do so is an act which the United Kingdom is carrying out pursuant to its continued unlawful administration of the Chagos Islands. So it's asking the court to give a decision not to notify, decisive effect in circumstances where its continued administration in carrying out the international relations of BIOT is itself
the other way around. You would have thought that if it had made a declaration, it might not be valid one.
Yes, and there is an interesting discussion in some of the cases about what happens.
You took that as a helpful observation, but as I understand it, it's a problem with your case, isn't it?
Well, there is an interesting discussion in one of the cases where something roughly similar happened, Loisedu, which we cited in our skeleton, about which acts which are unlawful in international law may still be recognised by the European Court of Human Rights. And the European Court of Human Rights essentially said, we're going to fudge that issue. We're not going to recognise acts insofar as they're used as an excuse to avoid our jurisdiction, but if it is necessary in order to protect legal certainty and individual rights to recognise an act of an illegally occupying power, for example, then we may do so. And they gave the example of recognition of property rights, marriage, bank transactions, and so on. And so the court's approach to the recognition of conduct which is unlawful in international law may vary, depending on the circumstances. But what I do submit is clear, is that the United Kingdom can't rely on its failure to make an Article 56 declaration in circumstances where its ongoing administration of the Chagos Islands is unlawful in international law, because it's relying on its own continued wrongdoing in order to escape the operation of the convention.
Isn't my Lord's point a complete answer to that way of putting it? The logic of your position is that any Article 56 notification would be unlawful, subject to the Loisedu. You've got to put all your eggs again in the Loisedu basket, haven't you? Oh, I see. That is your answer.
Yes,
your answer is this would be a Loisedu case.
It would be, indeed. And it's
But in that case,
In some ways, you don't need these arguments, but they're
quite.
taken about other ones.
Yes.
Anyway, you only have to get your foot in one door for this stuff.
Yes, I only need to get my foot through one door. But let's say, for example, I know my lords are familiar with the facts of Loisedu about the Turkish Republic of Northern Cyprus. Let's say that the Turkish Republic of Northern Cyprus had better legal advisors than they did, and they, instead of running a puppet administration behind the scenes, they simply decided to announce, we have annexed Northern Cyprus, and we are going to declare it as the overseas territory of Turkey. We are not going to make an Article 56 declaration, and therefore, game over. Because Article 56 is the sole route by which, according to the Divisional Court, jurisdiction may be extended to an overseas territory. Now, the answer to that is, of course, that as a matter of international law, the Turkish occupation of Northern Cyprus is unlawful, and therefore it will not be recognised by the court. But that's my submission. That where we are talking about the continued administration of a territory which is unlawful in international law, Article 56 is no longer the lex specialis. The proper means of identifying jurisdiction under the Convention is under Article 1, and the court will conduct its traditional analysis of identifying the degree or otherwise of control over the territory.
well, that's a slightly different way of putting it, isn't it? Yes. Okay.
What about victim? I didn't notice in your skeleton argument where you dealt with that. Okay.
Yes, can I deal with what the Divisional
Well,
Court said about
can I just be clear about this? And you were doing it systematically. You'd identified 4 points on which you needed to succeed.
Victim is the second one.
Victim is, had you finished all you wanted to say about the first one?
Pretty much, yes.
Yes, okay, well then, my lord was correctly anticipating where you were going next.
Can I just pick up what the Divisional Court said about the victim, so I can make sure I identify the points? They dealt with victim at paragraph 145 of the judgment.
All I took them to be saying is that you lost on victim status in Strasbourg, and so that's it.
Yes, that's right. The first point they make at 145 is that the claimant is not a victim because there's no right of individual petition under Article 56. There's no declaration. But that's
That plugs into the previous point.
that plugs into the previous point. So that's the link there. Then the other points they make are reliant on paragraphs 82 and 83 of the Chagos Islanders decision, which the court cites. So in paragraph 82 of Chagos Islanders, it said that the end of that quote, whatever the outcome of the proceedings, the applicants continue to have no legal or practical prospect of being able to enter or settle on the islands. Well, in light of the ICJ decision, that analysis can't, in my submission, stand, because there's a breach of international law of a continuing character. There is now a duty on the United Kingdom in international law to complete the decolonisation of the Chagos Islands immediately, and that duty includes arrangements for the resettlement of Chagos Islanders, and that is a matter of state responsibility. So that's paragraphs 177 and 178 of the ICJ's judgment. The second suite of points made are in paragraph 83 of the Chagos Islanders decision, quoted at 147 of the Divisional Court's judgment. And in essence, what the Strasbourg Court is saying there is that this is a historical matter. It was raised in the domestic courts, it was settled definitively, and it's part of a campaign to bring pressure to bear on government policy, rather than disclosing a situation giving rise to fresh claims under the Convention. Well, the Seychelles claimants, such as my client, were never compensated to any...
But I see you say that, but that point doesn't seem to have been... The Chagos Islanders case in Strasbourg was brought by Seychelles Chagosians just as much as by Mauritian Chagosians, was it not?
I'm not certain about that. Can I check? But nonetheless, the position following the International Court of Justice advisory opinion is that there is an ongoing illegality. It's not a purely historical matter, which is how the admissibility decision in Chagos Islanders characterised it. And also, at paragraph 181 of the ICJ's judgment, they characterised it as an issue relating to the protection of the human rights of those concerned, the absence of arrangements for resettlement. So, the suggestion in the Chagos Islanders decision, which the Divisional Court understandably relied on, that this is a historical rather than an ongoing issue, and it doesn't really engage today questions of fundamental rights, is in my submission incorrect as a result.
The ICJ opinion seems to talk about resettlement plans by the Mauritian government. I wasn't aware there were any, but that no doubt would be because they de facto don't have any control at the moment. Is it the case that this is the position of the Mauritian, declared position of the Mauritian government, that if they succeed in getting recognition of their right to control the Chagos Islands as a matter of international law, they will promote resettlement?
That's their public position, yes.
Right.
Well, Sir James says, where's that then? The answer is that's been repeatedly said by the Mauritian government on...
Well, there's there's an implicit reference to it in the... I haven't read every word of the ICJ opinion, but there is certainly a reference to it, which is why I asked you the question.
And of course the question, which was ultimately approved by the General Assembly, the two questions, were formulated by Mauritius, because Mauritius considers that as a matter of fundamental rights there ought to be arrangements for the resettlement of Chagosians. And I don't represent the Mauritian government, and so I can't say what their actual plans would be, but that has always been their public position, which is reflected in the questions the ICJ asked.
Thank you.
The third point on which the Divisional Court dismissed the Human Rights Act argument was the question of interference, and that's dealt with in the judgment briefly at paragraph 148. And it's the same point which is taken in relation to victim status, that the present case, they say, is not concerned with what may have happened, what happened in the 1960s or the 70s. It's concerned with decisions in 2016, not interferences with any of the rights in the Convention. For example, the right to peaceful enjoyment of possessions or the right to respect for the home. Now, there was considerable argument about interference before the Divisional Court. The claimant's submission was that it is correct that rights can be lost under the Convention where they have not been exercised for a lengthy period. But that is not the case where the deprivation has been the result of continuous wrongdoing, particularly where that wrongdoing is in breach of international law, or where the person has been physically prevented from exercising their rights. Now, that's what happened in Loiseau. Mrs. Loiseau was prevented from accessing her property for over 15 years, and the long loss of access was held not to be a bar by the Grand Chamber in that case, in paragraphs 43 to 44 of the Grand Chamber's judgment. And below we also cited an additional case as an example of that, which I won't hand up, but we have copies if the court wants it, called Dogan in Turkey, where there was a prevention of access to homes by the Turkish security forces for over a decade, during which the entire village collapsed. Now that case is potentially interesting and significant because one of the points taken by the Turkish government was that the villagers enjoyed no property rights under Turkish law. They didn't have title deeds in respect of their homes. It was a small farming community based on a relatively straightforward and simple lifestyle. And what the European Court of Human Rights said is that property rights, as interpreted under the Convention, is an independent autonomous concept and may well include customary rights, including a right to hunt, gather and fish, and to live a straightforward agrarian lifestyle. And they found a breach of those rights.
That's material to a point which possibly isn't picked up in the skeletons, but I saw in, I think, Lord Justice Sedley's decision in Bancoult 2, to the effect of, well, the Crown owns all the land anyway, so where do you get any claim under Protocol 1?
Yes.
That's the point you say Dogan gives us an answer. Well, I think we better have a copy of Dogan then.
Of course. My learned friends have already been given copies. Thank you. I'll just give the court the paragraph references, if I may, rather than...
yes,
The facts... I'll just wait for it to be handed up.
it is Dogan with a G, is it? For some
It is
reason,
with
the way
a
it's
G.
printed out, it's come out rather odd.
Yes, I think it has. I think it had a special Turkish character, which.
Oh, I see. Of course, yes.
The facts are at paragraph 38.
Well, you're the best judge of your time, but unless you particularly want us to, we won't go to these.
No, I won't. I'll just give you the reference,
Okay.
if I may.
Yeah.
So, for the facts, the court has paragraph 38, and then the conclusion on the Article 1 of the first protocol claim, including the analysis of whether the economic activities of hunting, gathering, fishing and traditional rights enjoyed by the villagers counted as possessions, is paragraphs 138 and 139. and then the same principles are applied to an Article 8 claim at paragraphs 157 to 160. Now, that wasn't a basis on which the Divisional Court expressly said I lost, but I need to establish that I've got some prospect of a positive claim, as well as responding to the Divisional Court. The final point on the Human Rights Act claim is the question of whether, if there is an interference, there is a breach, balancing the respective interests involved under Article 1 of the First Protocol or Article 8. Now, that issue was not dealt with by the Divisional Court.
Sorry, I'm just getting the structure of your submissions right. You started with the ICJ opinion.
Yes.
And in relation, then you identified the 4 elements in your claim. Items 1 and 2, you've really answered totally by reference to the ICJ opinion.
Yes.
And is that the totality of your reasoning on those, for permission purposes, points you want to make orally, on points 1 and 2? Or are you going to come back and deal with, as it were, the non-ICJ opinion aspects?
Well, I'm going to mention one point at the end about,
Yes,
let's assume...
It's just so I can get my thinking straight. Because the substantive rights points you've made are not related to the ICJ opinion at all.
My Lord's absolutely right about that.
Right, okay, fine. And now you're coming to breach.
So the final point is breach, which, as I said, wasn't dealt with by the Divisional Court, and it also wasn't a topic on which the Secretary of State made submissions below, because, of course, it's the Secretary of State's position that no convention rights exist. Now, there was therefore no material before the Divisional Court analysing whether refusing the Chagosians their right of abode and the opportunity to return to exercise their property rights or return to their homes is a proportionate measure in the circumstances. Now, one can understand that there would be a lot of arguments about that, but that wasn't a topic which was considered in argument or addressed. And of course,
so what's the formal position on that? As pleaded, you pleaded a interference.
yes, and
So matter and that it was disproportionate. There's a nice point. You probably know the answer to this. I don't. Whether the burden is on you to plead that it was disproportionate, but anyway, you did. And the Secretary of State, in the response in the Divisional Court, asserted that it was proportionate, or merely denied that it was disproportionate? I'm sorry if I'm being fancy. I just want to understand whether there was essentially a positive case advanced at the pleading stage by the Secretary of State on proportionality. You told us how it went in the hearing.
I will check, but I'm sure it was denied, or it was positively asserted that their decision was proportionate. But no reasoning was advanced in support of that, and the Divisional Court didn't deal with it. So,
All right. I just want to see what's an issue in the proceedings as opposed to how things went in the divisional. It's probably a marginal point. It might become relevant if we were to give permission and questions of respondents' notices and so on arose.
it is, and it might well be a point which was raised in a respondent's notice, and it would be legitimate for it to be raised in a respondent's notice.
Okay, thank you. Let's leave it for the moment.
Another way in which it could be dealt with is that if the court was not satisfied that this decision was proportionate, then the claim would succeed, but the Secretary of State would have to reconsider the question. I'm not suggesting, for example, and I said this before the Divisional Court, that a decision that there was a breach of the Convention would necessarily be the end of the road or the end of the picture, because it's perfectly possible there would have to be a new decision which was considered on different material and different evidence. So those are the 4 points that we make in relation to the Convention.
Yes. Can I, again, I'm just interested in formalities here so that we don't lose sight of them. Insofar as you're relying on the ICJ opinion, would that? And I appreciate this is a public law case, so there aren't private law pleadings. But it would require, would it not, an amendment in some form of your case? Now, I don't, it must be the case, I haven't checked, but it must be the case that you never asserted as part of your original case that the detachment of the Chagos Islands from Mauritius was illegal as a matter of international law.
No, we didn't plead that, although we did plead that Article 1 of the Convention was the correct route to finding.
Well, that's a different point. But not all, as we've just established, but most of the points you've been making now, and to some extent in your skeleton argument, are new points. And I see why they're new points, because the opinion came along. But if we were to give permission, I flag up, and we may have to hear from Sir James if this arises, how this ought all be formally put in place. I think it would be a bit sloppy just to say, well, you can read about it in my skeleton argument. So speaking for myself, as you would have gathered from my first observation, I didn't see how you really put your case. Maybe I just didn't read your skeleton properly, but I don't think it's quite as focused as it has been in your
more thoughts and visions.
Yes, that wasn't in any way meant to be critical. It was meant to be
No,
self-deprecating.
I take that point, and if the court were to give permission, it would be important that the exact target is set out precisely.
Let's not spend too much more time on it, but where in your skeleton argument do you actually make the points about the effect of the opinion of the ICJ? I know it's there, I've read it, but I can't.
It's from paragraph 35 onwards. In the bundle, it's tab 22, page 512.
Yes, it is. No, you're entirely right to say it is there, but it's been sharpened up a bit, the way you put it.
It is. I hope that most of it is there.
No, I think it is.
The same cases that I've relied on, but I've attempted to give it, I hope, a bit more structure in an oral argument.
And certainly a bit more prominence. Very well. At some point also, but this may not be the right point, it may make more sense to put it at the end, you will have seen, I assume, Sir James and his team's submissions opposing these applications, dated the 22nd of March.
Yes.
He makes 4 points why the advisory opinion is irrelevant. At some point, I think you should just go through those and check that you have said what your case is on those objections. Is now a good time? Or?
Yes. So paragraph 6 of my learned friend's note.
Yes.
First of all, they say it postdates the decisions under challenge and cannot for that reason alone support a rationality challenge to those decisions. Now, that's the point that's going to be dealt with by my learned friend, Mr. Fitzgerald, who's dealing with the right of abode argument. But the point there is that the advisory opinion in relation to my learned friend's argument goes to whether the Divisional Court was correct to say this is not a case in which anxious scrutiny should be applied, because the Divisional Court's view was that this case did not engage questions of fundamental rights, and therefore no anxious scrutiny when applying a rationality test is required. And our case is that that's wrong in law, and it would be wrong in law anyway, but that is confirmed by the advisory opinion, which indicates that questions of fundamental rights are engaged. So that's our answer to paragraph 6.1. Paragraph 6.2 says the advisory opinion does not make findings about any asserted right of abode or resettlement of those such as the appellants. It was concerned with the process of decolonisation.
Sorry, this is a very basic question. You're all international law experts. Is there a declaratory theory, so that, let us ignore the fact this is an advisory opinion that may have its own problems, but assuming this was a final opinion, or a final, whatever the correct final formulation as a matter of international law is, would it declare that would the effect be that what had happened when the Chagos Islands were detached had always been contrary to international law?
If the advisory opinion is a correct statement of international law, then yes, they're stating the position in law as it always has
That's
been.
what I rather assumed.
Now, of course, it would be open on a substantive appeal for the Secretary of State to argue that the advisory opinion is just that, it's advisory and it's wrong.
That's a distinct point. I think that's the point he comes on to make.
Yes.
But, yeah.
And I accept that would be entirely open to the Secretary of State to run that point, to say that they've totally misunderstood public international law, and in fact they're incorrect in the
Would you say
conclusions.
that would be rather heroic argument for us to accept at the commission
It
stage?
would be heroic at the commission stage, but I accept it would be open at a substantive hearing.
Okay, if it's been helpful, you're running through these points. You've dealt with the first.
6.2 does not make findings about any asserted right of abode or resettlement of those such as the appellants. Well, what the advisory opinion does do at paragraph 181 is to say that is an issue raising the human rights of the Chagosian people. Without saying what the answer is, without explaining what their view of the fair balance concerned is, but they explain that first of all the United Kingdom must cease its administration of the Chagos Islands, and secondly that the question of resettlement does engage issues of fundamental human rights. And so that is as far as I need the ICJ opinion to go in response to the Divisional Court's findings. So, for example, I don't say that it answers the question of what a fair balance might be. And so, for example, the balance that was struck between 2000 and 2004 was that Chagosians were permitted to have a right of abode in the outer islands, but they were not permitted to go to Diego Garcia. Or there may be numerous other arguments or solutions to the convention requirement of a fair balance. And I don't say the ICJ answers those difficult questions, but I do say the ICJ makes clear that they do arise. Then 6.3, advisory opinion doesn't create or support the existence or breach of a domestic legal obligation. Well, that's absolutely right, but I've explained its relevance to the convention arguments, I hope, in the course of my submissions. But I accept, of course, that the United Kingdom is a dual estate. I don't say that the advisory opinion reflects English law, necessarily, but it will be considered through the lens of the convention for the purposes of my arguments. Then it said it's an advisory opinion, doesn't bind even in international law the states concerned because it's advisory, and the United Kingdom has refused to consent to judicial settlement of the dispute with Mauritius. Well, that's fine, but I say the advisory opinion is persuasive as to the content of international law.
If this case were being argued at this moment in Strasbourg, would the Strasbourg court have regard to the advisory opinion as persuasive?
And it routinely does. It doesn't consider them to be binding, but it does consider them to be highly persuasive, given that they are the considered opinion of the International Court of Justice. And in this case, isn't always the case, having heard contested oral argument, the UK participated, and 20 other states participated in all directions of argument, making oral submissions to the ICJ.
So, again, you'll just have to forgive my ignorance. In order for the position to be definitively determined, the court would have no further role. That would be a matter for the General Assembly, is that right?
In order for there to be a definitive judicial resolution in international law, the United Kingdom would, I think, need to consent to a binding decision of the ICJ, which it has declined to do.
But can the issue nevertheless be definitively determined by an act of the General Assembly? Probably not.
Probably not.
No.
I think the General
So
Assembly...
it will always remain advisory unless the UK's position.
Yes, unless the UK consents to a binding opinion.
Thank you.
And then paragraph 6.4, court shouldn't place any reliance on it because the advisory opinion sits in the context of ongoing international relations controversy and the judiciary and the executive cannot speak with two voices. Well, that principle does not apply in the context of a disputed question of international law which arises through the lens of the European Convention on Human Rights. Because in every one of those convention cases where the Strasbourg court or our domestic courts have considered a question of international law through the lens of the convention, there has been a dispute. The UK has had a view, but the UK's view is not binding. The court will identify what the correct position is as a matter of international law. So that would be an issue if this was
When
a
you
pure-
say in all the other cases, which cases do you have in mind?
For example, and I'll just give you one example, the Serdar Mohammed case, which was ultimately determined by the Supreme Court. One of the issues in that case was about the proper interpretation of a number of UN Security Council resolutions. And the United Kingdom obviously had a very firm view, and Mr. Mohammed also had a firm view to the opposite effect. And the court resolved that question of international law on its merits, rather than saying the United Kingdom can't speak with two voices. And the Strasbourg court, the Grand Chamber, has recently done exactly the same thing in a case called Hassan,
Well, that's the one. These are the cases you referred to earlier. That's
where the court interpreted the Geneva Conventions
Yes.
and decided what they meant. And so I'm afraid, in my submission, those points don't get my learned friends home. Just before I move on then from the convention arguments, can I just mention, I said I had one point, which is
Yes.
that even if the ICJ advisory opinion is irrelevant, I do still say that the Divisional Court was wrong in its conclusions in any event. Because, and this really relates to the jurisdiction question, because the argument that was put against me before the Divisional Court, and which the Divisional Court accepted, is that, okay, well, there's two potential routes to jurisdiction. Article 56, where the United Kingdom has international responsibility for the international relations of a territory, and it makes a declaration, or Article 1, the Al-Scani type of case, where the United Kingdom has effective control over territory or a place. And the argument, and this was the point that was made but not decided in the Chagos Islanders case, as my lord put to me, is that this would leave Article 56 a dead letter. The real risk was that the right of a state to decide whether or not to apply the convention to an overseas territory would, in practice, be lost. Now, my response to that is that that's a bad point, and can I just take a practical example? Let's take Gibraltar as an example. It's a British overseas territory. It is self-governing and it is democratic. The United Kingdom is responsible for Gibraltar's international relations, just as with other self-governing overseas territories like the Isle of Man, the Channel Islands and so on. Let's assume that there's no Article 56 declaration in respect of Gibraltar. There actually is one, but let's assume there isn't. And let's assume that the Royal Gibraltar Police torture someone. What's the position if there's no Article 56 declaration? Well, that conduct of the local police is absolutely nothing to do with the United Kingdom. The United Kingdom doesn't exercise control over the local police force, and there would be no jurisdiction under Article 1, applying the Al-Scani line of authority. The United Kingdom is not in control of the police station, it's not in control of the police force, it doesn't make the laws, it doesn't control the Parliament. So the fact that there is, in fact, an Article 56 declaration in respect of Gibraltar is decisive to establishing convention jurisdiction. And so Article 56, on the appellant's analysis, is certainly not a dead letter, because any overseas territory which operates applying the principle of self-determination, in other words, which manages its own internal affairs, would not meet the Article 1 test of effective control. Now, of course, I say the position is entirely different in Biot, which is, in effect, subject to direct rule by a civil servant who is the commissioner from the Foreign Office, who has the power to make laws and act as the executive.
Suppose that is an arguable point. What is the status of Bancoult 2 as binding authority? As you say, the reasoning is based entirely on Article 56, but the decision is that the Convention does not extend. You say yes, effectively you say yes, but the right point wasn't taken. It should have been run on an Article 1 basis in the alternative. But is it open to a lower court? Oh, well, we come back to a point you've already addressed, I
When you
suppose.
say that's that's itself an arguable point. And if you're wrong about it, then it
Yes,
should go to the Supreme Court anyway.
it may be at the substantive hearing that the court would feel compelled to follow the authority of Bancoult number 2. It might or might not wish to comment on whether it agrees with Bancoult number 2. That would be a matter for the court. And then this court would be able to grant permission if it thought appropriate.
I mean, that is, which is really the point you trailed earlier in connection with the...
And the point which I made below is the consequence of all of this is that if the Divisional Court is right, the British Indian Ocean Territory is the only place in the world where the United Kingdom could, for example, torture someone or unlawfully imprison them.
This is the concession which you
It's a
said James
non-concession.
made, and he says he didn't.
Well, I'm happy to accept what the Divisional Court says, that it's not a concession. But the
Well, anyway, you can argue
point
that
remains
there's no
good.
difference in principle between the territory you've just occupied recently, as in Iraq, or a territory you occupied a while ago, but still under occupation.
I mean, let's say, for example, the United Kingdom unlawfully and belligerently decided to invade an island, let's say an island in the Maldives, and decided to call it an overseas territory and annex it. In those circumstances, does the Convention apply if the United Kingdom were to commit serious breaches of the Convention there, just because they call it an overseas territory? Well, because the United Kingdom is unlawfully
We have
in
the
effective
point,
control.
yes.
That's the Convention argument. Can I turn and deal now with the remaining 2 points, which I have to make? First of all, the public sector equality duty. The Divisional Court deal with this from paragraph 150 onwards in their judgment. At paragraph 150, the duty is set out. It's obviously familiar to the court. And then paragraph 152 records an actual concession, which is that for the purpose of the present proceedings only, it is conceded on behalf of the defendant that Chagosians form an ethnic group within the meaning of the Equality Act 2010. The original position of the Secretary of State when pleading his defence to the case is that the Chagosians were not an ethnic group. And the reasons that were given for that in the original detailed grounds of resistance are because the Chagosian people have no continuity, as it was put, with a pre-colonial society. That wasn't a very powerful point, perhaps, because, for example, it would mean that if it was correct that Afro-Caribbean was not a distinct ethnic origin, the fact that someone's ethnic origin results from a common shared history of, in this case, slavery and colonial society doesn't make them any less an ethnic group. Now, the reason why this was an important point below was because there has, for some decades, been something of a disagreement about the status of the Chagosians. The government's original basis for removing them is that there were no indigenous people on the islands. They were just a group of contract workers who were there working on the plantations, who were there with their families. The true position is that the Chagosians had been on the islands for the best part of over 200 years. They had arrived there as a result of slavery. They had developed a distinct culture and a separate language, and they were the indigenous people of those islands. And it is the failure to recognise their status as having a distinct ethnic origin that formed the basis of the public sector equality duty complaint. Did the government actually recognise that the Chagosians are a people, sharing a distinct ethnic origin, or are they just a group of contract workers and their families who've lived on the islands?
The answer to that, which the Divisional Court gave, is maybe they didn't, but they did everything that they would have had to do if they had in fact recognised the Chagosians as an independent, as an ethnic group. And that is why they say there's an air of unreality about the whole of this complaint. What is your answer to that?
Well, my answer is that it is one thing to decide to bar a group of migrant contract workers from the islands where they worked, where they share no common characteristic apart from a common employer. It is another thing, in terms of giving due regard, to maintain the permanent exile of a people who have a shared ethnic origin, which includes language, belief, customs, and a society, from their homeland. And giving due regard to one of those is not the same thing as giving due regard to another. And indeed, that's why the public sector equality duty would not apply at all to the exclusion of a group of contract workers from the islands where they worked with their families, but it does apply when they share an ethnic origin. And what there wasn't in my submission is any evidence of any understanding within government at the time the decision was taken that the Chagosians shared an ethnic origin. And
What
that's
in substance would have been done different?
well,
That we have an assessment done of the impact on the islanders, including various, you say, much less important Equality Act matters, but nevertheless, the whole exercise is one which assesses the impact of the decisions that are going to be taken on these people as a group. Would it really have been any different in character if they had been regarded as a group with an ethnic, with an identity of the kind you've identified, as opposed to a group with simply a shared history of descended from contract labourers?
my response to that is I don't know. And the public sector equality duty does not create any obligation of substantive outcome. But it does require in my submission proper attention to be given to identifying the potentially relevant protected characteristics. And in light of the very difficult history of the government's approach to the Chagosians and the fact that they originally pleaded that the Chagosians were not an ethnic group, they needed to properly consider and analyse and give due regard to the fact that the Chagosians were an ethnic group and consider the particular disadvantages of their decision to the Chagosians as a people sharing an ethnic origin and a homeland. And that's in my submission what they failed to do.
Well, thank you. I see how you put it.
The third and final point that I'm going to deal with is the support package. The support package is dealt with by the Divisional Court from paragraph 300 of their judgment on page 102. The existence of the support package is, as I've already said to the court, a matter of particular interest to the Seychelles Chagosians, because to no extent have they ever been compensated for their removal from the islands. We are now, I think, nearly 3 years away from the November 2016 decision, and I think none of the support package, apart from funding for a couple of visits, has yet been dispersed. Now, the support package was intended to be the mitigation for the decision that there would be no resettlement and the right of abode would continue to be deprived to the Chagosians. The court's analysis, if we can pick it up at paragraph 306 of the judgment, explains how we ended up with a figure of approximately £40 million for the support package. So there was a DFID proposal showing a figure of 20.5 million for Mauritius and 6.6 million for the Seychelles, and that adds up to 27.1 million. And the Foreign Office was going to offer a separate package from their budget of 19 million. And that adds up to over 40 million, nearly 46 million. What happened, and I should add, that was behind that there was lots of documentation. It was a costed package of providing
Yes, well,
particular
we've read.
healthcare facilities and so on. It then dropped to 40 million. And the reason for that is the entirety of DFID's contribution relating to the Seychelles was removed. And the reason for that is that DFID concluded that the gross domestic product of the Seychelles per person was too high for it to fall within DFID's ordinary funding criteria. Although it's fair to say that they did recognise that the Chagosians they were looking to assist were an underclass within Seychelles royal society. So basically they didn't want to pay for it. So they reduced their contribution to 20.5 million. So you add in the Foreign Office money and you get to 40 million, which is the sum announced. The difficulty is that ministers were told that you could do all of these things with 40 million, but in fact you can't. The entirety of the extent of the funding contribution relating to the Seychelles had come out. Now that submission, which Mrs. Hoareau made, is recorded at paragraph 311 of the judgment, and the court gives two answers. First of all, at 312, the court say it's an approximate and indicative sum. Now, that would be a good answer to the disappearance of this sum if the defendant's position was that it would review the funding in light of this error, and they would reconsider whether or not, when finalising the support package, a mistake had been made, and they would consider whether, in order to achieve the package of measures which was put to ministers, additional funding was required. But that's not, so the appellants understand the Secretary of State's position. And so the fact that the sum is not absolute and final, not least because it's being delivered over 10 years, doesn't provide, in my submission, an answer. The second point, which is made by the Divisional Court, is at paragraph 318, and it said that ministers did not have less information than the law required, nor were they materially misled. And the court says there's no suggestion that the Seychelles Chagosians were to be excluded from the support package. Well, I respectfully agree with that, that's right. It's not suggested that the remaining money, none of it will be given to the Seychelles Chagosians. Of course, some of it will. But the overall package will not be able to achieve what was put to ministers on the basis of the cost. So at some point in the future, unless it's reviewed, someone will have to take a hit and the package will not be able to be achieved. Then the court says the fact that ministers were not told of the missing 6.6 million doesn't vitiate on grounds of irrationality the decision to commit in principle. And I think that's the same point, that it's only a decision in principle. So, at the simplest level...
So really, you say point two, assuming this is a correct analysis, that the Divisional Court regarded this as a separate point. It's not really a separate point, it's the same point.
And the upshot of this is simply that, in my submission, the support package requires reconsideration. Now, the outcome of the reconsideration is properly a matter for the Secretary of State. So the Secretary of State might say, well, we see that an error was made, but we can't afford it now, so we're not going to increase it. We see that an error was made and we're going to do something in the middle. Or we see that an error was made, but on proper analysis we think we can achieve all these things anyway. Or we see an error was made, but...
Perhaps the analysis that what they committed to was a support package that would do various things.
And it can't.
Well, no. If the correct analysis is that what they committed to, the fact that they thought it would only cost, they thought it could be done for 40 million, whereas maybe it can't be, wouldn't matter because they are committed, whatever that means, but that is the decision, to delivering that support package. Not we're committed to spending 40 million, or we're committed to doing A, B and C, and they'll have to do A, B and C unless they change their commitment.
Well, I think the Secretary of State might cavil at that. I think the Secretary of State might say that was in an indicative budget proposal. But the defect which the claimant says, or the appellant says exists, is that the proposal which was put to ministers for approval can't be achieved for the amount that ministers were told it could be achieved for. I mean, I think I must accept that over the course of the next few years, for example, ministers might decide, well, we said we were going to provide the following number of healthcare centres. In fact, we're going to adjust that in light of experience, and we're going to spend some of the money on university scholarships instead. But in terms of what ministers were told they could achieve with a certain sum of money, they can't actually achieve that. And so when fixing the indicative amount, an error was made that requires reconsideration. Unless I can be of any further assistance to the court, those are my submissions.
No, thank you very much. Mr. Fitzgerald.
My Lords, I'm going to focus on the first of our grounds because the second of our grounds is simply to adopt the submissions of my learned friend. And, my Lord, the issue, therefore, is whether the anxious scrutiny test, the enhanced Wednesbury test, should have been adopted or whether it was appropriate. As the court found, paragraph 104, to simply adopt a normal Wednesbury test. And, my Lord, I've got really 5 submissions in support of that, but if I can just first take you to paragraph 104, which is the key passage, and backing up at paragraph 102, the court, page 62 of the bundle. In the present case, both Mr. Fitzgerald and Mr. Jaffe relied upon the statement of principle in ex parte Smith, and that is that the more substantial the interference with human rights, the more the court will require by way of justification before it is satisfied the decision is reasonable in the sense outlined above. And then they outlined the fact that we relied on the enhanced level of scrutiny under the Smith test, and they found we do not accept those submissions. We do not consider the present case concerns fundamental rights at common law. And then going on, this is not a case where fundamental rights are affected, unlike ex parte Smith. This is because this court has to proceed on the basis that the legal rights which existed previously have been extinguished at least by the 2004 orders. The validity of the Constitution order was considered and upheld by the House of Lords in Bancoult 2 and again by the Supreme Court in Bancoult 4. There is not and cannot be any challenge before this court in the present proceedings to the 2004 orders. So that's the approach that they adopted, and we respectfully...
Well, that's true up to a point. I mean, it is the approach they adopted, but it is not the totality of the approach they adopted. At least as important to their thinking is what they go on to say at 105 to 108.
You mean about, yes, well, they then set out the nature of the decision, the issues that it raises, yes.
You say that very dismissively. It's clear they attach great importance, particularly to the further passage from Sir Thomas Bingham, which they refer to at 108.
Yes, about the nature of the policy.
Yes.
Well, my Lord, of course I accept that those are relevant factors, but what we respectfully submit is this, that if in fact what is at issue are fundamental rights, and we submit that that is the case, then the more enhanced scrutiny test should be adopted. And can I just summarise in, I think, 5 propositions why we say that the correct test is the Smith test, or the Book Dark Eye test.
What did you say after Smith test?
The Book Dark Eye test. I think it was in the case of Book Dark Eye.
Book Dark Eye. Yes, I've never known how to pronounce it, but you clearly...
Well,
my Turkish isn't very good, if it was Turkish. It's okay, now I know what you mean now.
Yes,
can we call it anxious scrutiny?
Anxious scrutiny, exactly.
There's a great deal of, as you don't need to be told, judicial and extrajudicial scepticism about exactly what the test is and how it's justified, but you're entitled to say at the moment it's recognised.
Yes.
Yeah.
And so, my Lord, the first point we make is that the decision does affect the human rights of the islanders. the question, just putting it broadly, the question was whether to restore the right of abode, which they undoubtedly had originally, and resettle them in their homeland, from which everybody accepts they'd been wrongly removed and from which they had been wrongly excluded historically. The background, moreover, is the recognition that the constitutional ban in the 2004 order needed to be revisited, and that's the words of Lord Mance in Bancoult.
Is this your first point still?
Yes.
Right. It's really a distinct point, isn't it?
Yes. Well, sorry, I'm
sorry. I'm just trying to think about it analytically.
Your Lordship's entirely correct. It is. So, just stopping at whether to restore the right of abode and resettle them in their homeland, that obviously engages fundamental human rights. Don't extinguish a right by simply a statutory provision which is itself to be reviewed. The second point we make is that the removal of the right of abode in 2004 was only justified on a contingent basis because of the lack of feasibility then. And can I just take your Lordships to the relevant passages? First of all, Lord Hoffman made it clear in Bancoult number 2, firstly at paragraph 23, that what he was looking at is a history in which the idol of the old life on the islands appeared to be beyond recall. Does Mo have
I'm sorry, no, I was listening. I'm
Yes.
afraid I wasn't
Of course.
looking, but I will.
Well, that's, yes, paragraph 23, if I can just...
Give me a moment, and I will find it. 102, paragraph 23. Yep. Yep.
And so what one sees there, he sets out the factors that had changed since the original idol had been enjoyed and the homeland had been occupied. And he refers to a number of matters, whether aircraft could land, the matter of the sea defences, and the fact that the activities of the islands would have to be very different. If I can take you on from there to paragraph 56, G, he recognises the contingency of the situation when he says at paragraph 56 at the start, it is true the Chagos Islanders will now require immigration consent even to visit the islands. And then he goes on, furthermore, at the last sentence there is no reason why, if at some time in the future circumstances should change, the controls should not be lifted. In other words, this is, given the Posford-Haskening report and its finding as to feasibility, is the decision taken then to remove the right of abode defensible on rationality grounds. Then if I can take you on to paragraph 58, he then relies on the policy as to the expenditure of public resources and security and diplomatic interests of the Crown, particularly within the competence of the Executive. And it seems to me quite impossible to say that the decision to reimpose immigration control was unreasonable or an abuse of power. But I will take you to the fact that he, in fact, and Lord Carswell did apply the enhanced scrutiny test themselves. But the point I'm on now is that it's a contingent decision. Paragraph 100.
While we're on that, do you accept what Lord Hoffman says at the top of paragraph 55? Really, the second sentence.
The funding is the subtext.
Yes.
Well, yes, it depends what you mean by the subtext. If you mean there's an A and a B, one is, the A is, do they have the right of abode? And B, should there be funded resettlement? And the two are are closely bound up, but we
Well, I think closely, yes, I
We don't-
asked that because the Divisional Court makes the point itself that although analytically
Yes.
you can distinguish the right of abode and funding of any exercise of the right of abode, the Divisional Court proceeded on the basis they were not just intimately bound up, but inextricably bound up. The first is empty without the second.
well, we submit it remains an important symbolic right, and a right which should be the proper starting point of any inquiry, and so that's our respectful submission.
Thank you.
So
Sorry,
that argument was rejected in Banco number 2, wasn't it, by the majority? The argument you've just expressed. I mean, they said that if symbolic rights isn't worth having. I mean, Lord Hoffman dealt with that in Arrow 53.
Yes. Well, I think the ratio, my lord, would probably be this.
Yeah.
If the right simply can't be exercised, it's completely unfeasible, then it means nothing. But then that depends on how unfeasible it is to exercise it.
But there's no such thing as absolute unfeasibility. If you devoted enough resources, you could do anything you liked. It's all a matter of degree.
Well, my lord, what we submit is that there is a distinction between the finding that it wasn't in fact feasible, on which the decision was premised in Bancoult number 2, and the position as it now is. That there is a distinction to be made between it's not feasible and it is feasible, but it's difficult. And if one looks at the totality of, well, you've just seen what Lord Hoffman put forward at paragraph 23 as looming over it all was the prospect that the island would be, as it were, submerged, that has been dealt with. And we respectfully submit that the point about the cyclone belt didn't reappear. If one goes on from there to Lord Roger at paragraph 112, he sets out the reasoning again about the difficulties and the problems of flooding at 112 at G. Human interference are likely to exacerbate stress. Flooding would be likely to become more frequent, threaten the infrastructure, and one sees there that was the background against which Mr. Rammell said that the restoration of full immigration control was necessary. And so that's Lord Roger's approach. And then if one goes on to Lord Carswell's approach at paragraph 132, he categorically, first of all, endorses what Lord Rogers says, and then in his second sentence says the feasibility report makes it abundantly plain that resettlement in the Chagos Islands, even with substantial financial support, would have been impracticable. And then he sets out the problems about ecological factors and those other matters. And also the position of the United States is set out at paragraph 132C, wanting to keep the whole of the territory free from settlement. And
Just remind me, is that now any more a problem? The impression I've got, but I'm not a master of the detail, is that whereas, of course, they wouldn't want any resettlement on Diego Garcia.
that's right. That's one of the things that we respectfully submitted had altered.
Yeah.
It's not impossible from the point of view of climate. And the US position is not to oppose resettlement on the outer islands, but to say that they don't want people flying through Diego Garcia. And so that's basically why we submit this as a contingent decision, which Lord Hoffman expressly said might have to be reviewed, indeed would have to be reviewed if things change. And then
there's a certain chicken and egg question about whether it involves fundamental rights, though, isn't there? Because if the question of whether it involves fundamental rights depends on whether it's feasible to resettle, then You've got to decide that question first. But you say, well, when you're deciding that question, you've got to give anxious scrutiny.
Yeah, but my lord, we say if the subject matter is about whether to restore the right of abode, that's our first point. That subject matter is about human rights. Do you restore the homeland to people who've been wrongly removed from it? It's a human rights issue, full stop. But even if you look at the reasoning of the House of Lords in 2008 in Bancoult number 2, they were saying that at that time the right had been removed justifiably because of the factors that they found to be reasonably taken into account. But the right, if it is possible to return to a homeland, is a subsisting right. It derives from the fact that it is the place to which Mr. Bancoult belongs, from where he was born, where his family are buried, where he wants to return. So, my lord, I don't know whether that helps to answer the point, but we say that of course it's about fundamental rights. Can you return to your homeland? But secondly, even the House of Lords decision was a contingent one. And then the third point we make is that the test applied in Bancoult number 2 itself was the Smith test, and I can just refer you to that. Lord Hoffman applies the enhanced, or accepts the application of the enhanced test. He cites it at the end of paragraph 52 and then applies, says that it's applicable at paragraph 53.
Let me just look at that.
So if one looks, he recites at the end of paragraph 52 the argument of Sir Sidney Kentridge, where a measure affects fundamental or has profoundly intrusive effects, the courts will employ an anxious degree of scrutiny. And then he says, I would not disagree with this proposition, which is supported by a quotation from Sir Thomas Bingham in Ex parte Smith. However, I think it is very important in deciding whether a measure affects fundamental or has profoundly intrusive, once you consider what those rights and effects actually are. Now, it's quite right that he goes on to say, well, they haven't enjoyed them realistically over the past decades, but he doesn't dissent from the proposition that the Smith test applies.
Well, I think he does, doesn't he? What he says he doesn't disagree with is the proposition that where a measure affects fundamental rights or has profoundly intrusive effects, anxious scrutiny is required. But he says that isn't the case here.
Well, and then if one goes right down to the bottom, when the legislative body is considering a change in the law which will deprive him of that right, it cannot be irrational or unfair to consider the practical consequences. That doesn't seem to be saying that though you consider the practical consequences, you don't apply enhanced scrutiny. Well, my lord, can I? Maybe I have more assistance from Lord Carswell, who expressly does apply.
He's saying all it really amounts to is the right to protest. That seems to be Lord Hoffman's reasoning. He's the least faithful to it, I thought.
Well, my lord, the fact that he endorses the test at the start of paragraph 53, I do say assists. I agree one has to read on, but he starts from the proposition and returns to it at 53G. Can I just take you on to Lord Carswell? And Lord Carswell, at paragraph 131, he sets out the test of Ex parte Smith at paragraph 131 at F to G, exactly the same test as we rely on. The time at which the factors governing reasonableness have to be assessed is self-evident in the time of making the decision called into question. One must therefore look at the situation obtaining at the time when the orders were made, consider whether it was reasonable in the Wednesbury sense as qualified by Smith to prohibit Chagos Islands. And then it is that he adopts Lord Roger, and effectively his finding is that it's effectively impossible, as the court's seen. And since he was, if I can call it the decisive vote, it is of some significance that he not only applied enhanced scrutiny, but really says it was just impracticable, and as my lord has observed, relies on the fact, which no longer obtains, that the US are opposed to any resettlement of the outer islands.
It's not so much detail, is it? I see his ratio at opposite D,
Yes.
which is very much like the other passage from Sir Thomas Bingham. It's decisions about how far to accommodate such concerns and wishes are very much a matter for ministers, and a bit about pinning a butterfly to the wheel. And then it doesn't look to me, he starts by saying anxious scrutiny appropriate to fundamental rights, but what follows is much like Lord Hoffman is, and saying, yes, but this isn't that sort of situation because of the kinds of decisions that were going to have to be taken.
Well, my lord, really what I submit is the reasoning there is that it has become clear, abundantly plain, that resettlement would have been impracticable. In other words, that's consistent with an anxious scrutiny. You're saying in order to trump some fundamental right, you've got to have a very good reason, a very strong reason, but there is here impracticability, and it's unqualified impracticability, and there is the opposition to settlement in the outer islands. So, I mean, one doesn't ignore the value of objections founded on resources and security concerns because one's applying anxious scrutiny. But one is more exacting in, well, is it really necessary? Is it really impracticable? So my submission is his conclusion was, well, it is. And, well, I know the court will be aware of the fact that the view taken by the other judges was it isn't. In other words, they're all applying, in our submission, anxious scrutiny, but just coming to a different conclusion. But now that the factors are different, we submit it was perfectly appropriate, and indeed we submit reasonable for the Divisional Court in our case to reach a different conclusion, given that the circumstances have changed. And my lord, that was the third point, that they did in fact apply the Smith test there, obviously subject to the points that my lord has made. The fourth point is that the decision in Bancoult number 4 contemplated that the constitution order would have to be revisited. And that's Lord Mount's, so it's tab 6, Bancoult number 4 in 2016, Lord Mount's at paragraph 72, and the court has that page 331. There is one other factor which would have been both relevant and, in my opinion, decisive had I reached a conclusion that the threshold test for setting aside was or might have otherwise been satisfied. And then the applicant submits that nothing other than a reversal of the House of Lords decision will overturn the constitutional bar on their return to the Chagos. But there's been a new 2014 to 2015 feasibility study published by KPMG, and it looks at the possibility of resettlement on Diego Garcia itself. There would be scope for supported resettlement. In practical terms, the background has shifted, and logically, the constitutional ban needs to be revisited. Now, the constitutional ban is the removal of the right of abode in section 9 of the 2004 ordinance, and he's saying logically it needs to be revisited. The Divisional Court said, well, that doesn't really mean that much. We respectfully submit that those words are very strong words. Logically, the constitutional ban needs to be revisited. And it may be it was a secondary part of the ratio of that case, and that's made all the more clear if one looks on to Lord Clark, who adopts those very words about needs to be revisited at paragraph 79 over the page, as it were. In the light of the results of the study, the government will no doubt consider whether, as Lord Mance puts it, it's appropriate to permit and support resettlement, expressly accepted on behalf of the government that it will be open to any Chagosin to challenge the failure to abrogate the 2004 orders in the light of all the information which is now available or becomes available. For example, it will at any rate in principle be open to Mr. Bancoult to institute judicial review proceedings to challenge any future refusal of the government to permit or support resettlement, as in Lord Mance's words, irrational, unreasonable, disproportionate. And so he is contemplating that there will have to be a reconsideration.
But there has been. I mean, the question is whether it's still impracticable to resettle
my
or
lord,
not, and if it is, then you still where you were with banker number 2.
my lord, yes, I'm simply indicating what is the level of scrutiny that was contemplated.
This is neutral on that, isn't it?
Well, the word disproportionate surely is an indication. You don't the whole meaning of the word or disproportionate is
You pin it all on disproportionate. Wouldn't help you at all if it said irrational or unreasonable.
Well,
you say anxious scrutiny or disproportionate really is code for Lord Mance was intending it to be on the anxious scrutiny basis.
well, it certainly would indicate, if you look back at paragraph 75, Lord Mance, again, he's talking about irrational, unreasonable and or disproportionate.
Yeah, certainly he is.
So, well,
Well, in fact, he says, whichever may in context be the right test. So he's
yes,
leaving it neutral, isn't he, what the correct approach will be, saying it'll depend on the context.
well, yes, my lord. If one well, if I can just sort of back up for a moment, then. If the issue is whether the original right of abode should be restored, they are contemplating that there has been a change of circumstances such that the ban from 2004 should be revisited. Then the question is, what test should govern that exercise? And they are clearly contemplating that it would extend to consideration of proportionality, which must be an anxious scrutiny.
Your point is, if it's characterised as a reconsideration of the fundamental question of depriving right of abode,
Yes, my lord, that,
then it will be anxious scrutiny, and Lord Mance, to put it no higher, hinted that by including disproportionate in his list of tests.
yes.
Okay.
So you have an original right, it's been unlawfully de facto taken away in the 70s, it's restored in 2000, it's removed, and the removal is upheld on the basis of a particular set of facts in 2004, but applying the Smith test, and then it's accepted that it has to be revisited whether those original rights should be restored. Certainly I submit that the proper interpretation is that revisitation should be a full-on Wednesbury review with anxious scrutiny. That's really the way we put it. The final point, my lord, is that the advisory opinion of the ICJ itself recognises that there is an ongoing human rights issue raised by the failure to resettle. My learned friend,
Yes, I don't think
Mr.
there's
Jaffe,
something special you want out of it. We've seen the passage in 181.
in 181, my lord, yes. So those really are the 5 points, and we say that with great respect to the court and Lord Justice Singh, the rather dismissive that no rights are engaged here, no fundamental rights engaged here, is plain wrong. Of course, when you're deciding, exercising anxious scrutiny, whether those rights should be overridden, you can have regard to the importance of the court treading carefully where issues of resources or national security are involved. But that's different from saying you don't start by saying this is an exercise in which human rights are involved. It's rather like those license cases where originally you take it away and then you decide whether to restore it. The courts have long said that the fact that you're deciding restoration of someone's, let's say, livelihood doesn't, and it's been taken away in the past, doesn't really alter the substance of the test. We're looking at substance. What's this about? It's about whether people who've been wrongly deprived of their abode should be given back that abode. And that, if one looks at that substance, really to say, oh, well, that's all been, there's no rights any longer, they've been settled in 2004, is, with great respect to Lord Justice Singh, oversimplistic. And, my Lord, that's really what I have to say in support of the test being the wrong test, and we say that there's certainly a realistic prospect. I would hope that we would persuade this court that is the appropriate test. Now, if that is the appropriate test, firstly, because they didn't apply the correct test, we submit that it must be arguable, there must be a realistic prospect that the Court of Appeal would reach a different view. But secondly, we've given one example, that's to say you can't land an aircraft on the outer islands point, which we've set out in the skeleton. That featured in Lord Hoffman's reasoning in the passage I've shown your lordships. The Permanent Secretary was saying that to the committee that made the decision, it's impossible to land an aircraft on the outer islands, which are the size of Hyde Park. In fact, in our respectful submission, that was misleading. You can land an aircraft. Indeed, there was evidence from both the KPMG report and indeed from the earlier report that you can land an aircraft there. And indeed, a number of sites have been identified where you could land an aircraft. Hyde Park is quite big enough in dimensions to land an aircraft in any event. And the land mass is 9 times that of Hyde Park, which is quite substantial in any event. It was just misleading, we respectfully submit, to present that position, that it was impossible to land an aircraft there. And if you're taking a decision on feasibility, one of the first things you're going to ask yourself is, well, is it possible to have communications with the outside world to bring people and goods in there? My Lord, it's all set out in this point in our submissions, but you can see if one looks at Lord Justice Singh's judgment, he deals with it.
Well, hang on, I'm just trying to. We've heard a lot about landing an aircraft. It's not, I think, one of your grounds of appeal that the decision maker was misled by what was said about landing an aircraft.
Yeah. Well,
if it is, I've missed it, and you please feel free to put me right.
well, my Lord, do you have the amended skeleton argument?
No, I'm looking for grounds of appeal.
Oh, I see.
I thought the grounds of appeal were, one, a wrong finding that the decision did not require enhanced scrutiny.
Yes.
The essential arguments being the ones you just advanced.
Oh, yes, I see.
And two, the relevance of the convention on which you adopt
Yes.
what Mr. Jaffe said.
Your
This, an argument that they were misled about landing an aircraft would have to be a specific ground.
No,
it? I haven't found it anywhere.
My Lord, your Lordship's entirely correct. This point essentially goes to, would it have made any difference? But we say, and that's how it's set out in the amended skeleton from paragraph 17 onwards, that if you...
Illustration of what,
Yes.
Of what got through the net on non-anxious scrutiny, but when it got through the net on anxious scrutiny.
Well, to the argument from my learned friend, which is advanced by my learned friend for the respondent, look, it wouldn't have made any difference. We say, one, it would make a difference to the issue of right of abode,
I mean, you're
I mean, you do say in your grounds of appeal this application of the wrong legal test materially affected the court's approach.
Yeah.
You don't give particulars of it, but we could ask you to do that if we thought this was.
and you say your particulars appear from your skeleton.
Yes.
I just wanted to see how it worked legally.
Yes.
I mean, we may or may not have to hear from Sir James about this, but on the whole, arguments, well, we did apply the wrong approach, but it wouldn't make any difference. Don't get very far at the permission stage.
Well, my lord, in that case,
I'm not telling you I went
No.
on that, but I wouldn't have thought that
Yes.
we'd need to hear Mr. Eady on why that was a knockout at the permission stage.
my lord, in that case, the context in which it was developed in the skeleton was to show that it could make a
I
difference
understand that,
to
thank
both those issues. But we say it was, as a matter of law, the wrong approach. It's very clearly stated by Lord Justice Singh at paragraph 104. He says categorically
Really made that point.
at that point, and we say that had he not misdirected himself in that way, the result may well have been different. I don't think I have to go any further at this stage, but that is our respectful submission.
Thank you very much.
Oh yes, my lord. I'm very grateful. My learned friend Mr. Harris has pointed out that we also have made submissions on some other compelling reason, which are set out in the skeleton at paragraph 25 onwards.
Yes,
and that's-
we won't overlook those. I'm not sure they need oral development. If there's something you particularly want to...
No, well,
So we
my
won't
lord,
stop.
it's the overall context, but the overall context made sharper and more accentuated by the recent decision of the ICJ and their comment at paragraph 181. My lord, those are my submissions.
Thank you very much. Well, that's, as tends to happen, you're, knowing you should go to one, you've gone to one. That's not a criticism. Sir James, I'm anticipating that you're going to say that you would wish us to hear some submissions from you at 2. If you say no, then we'll know where we are.
Well, I think I ought to say something at least about the ICJ
Yes.
decision. I wasn't planning on picking up all of the points.
No,
really.
well, I think that's very appropriate. What we will do is we will think whether there are any points apart from that one on which we would specifically like you. I'm afraid we won't tell you beforehand, so you'll have to do it on your feet, but you're used to that. 2 o'clock.
All rise.